The sequential dismissals of the Anjuman Intizamiya Masjid Committee's challenge to the Varanasi District Judge's July 21 order for a survey by the Archaeological Survey of India, first by the Allahabad High Court on August 3 and by the Supreme Court on August 4, further tightens the noose around the Gyanvapi Mosque, which is more than 350 years old. By overriding the objection of the Mosque Committee, the two courts also virtually sounded the death knell for the Places of Worship Act, the constitutionality of which has already been challenged by a lawyer linked to the BJP and is currently pending before the Apex Court. The hearing on this law that was passed by the P.V. Narasimha Rao government to oppose the BJP in September 1991 has become virtually meaningless now, as the Hindutva cavalcade's demand for a temple in place of Gyanvapi Mosque cannot be halted once the ASI declares that temple-like structures lie beneath the mosque site. The Rao government's important piece of legislation was aimed at enabling a resolution of the Ram Janmabhoomi Babri Masjid conflict in favor of the Hindu parties. As a reciprocal or balancing gesture, the state was given the responsibility of maintaining other disputed shrines in the country as they existed when India became independent. This law basically assured religious minorities and other citizens who do not support Hindutva politics that the state will not allow the Sangh Parivar's Demolish-mosques-to-restore-temples program to run till eternity. By permitting ASI survey on the Gyanvapi shrine, the Apex Court has not only opened the Pandora's box but has also now chosen not to have the contrarian final word, which is consistent with its past stance on certain occasions. Instead, it decided to endorse the orders of the two other courts, the Varanasi District Court and the Allahabad High Court. Depending on the outcome of several political events over the next couple of years, especially elections, nationally as well as for state assemblies, there is a likelihood of a new shrine being added to the to-be-restored list. But more gloomily, there is a clear possibility of dramatic or even destructive developments over the contentious Varanasi shrine prior to the parliamentary polls due next year. The 1991 law was seen as one that put a lid on other disputes while keeping the Ayodhya conflict out of its ambit. The 5-judge Ayodhya title suit bench included current CJI Chandrachud, and it described this law as emblematic of the basic structure of the Indian constitution. It was stated as being intrinsically related to the obligations of a secular state and a law that reflects the commitment of India to the equality of all religions. This faith got greatly eroded in May 2022 when the Supreme Court declared that the determination of religious character of a site is not barred under Section 3 of the Places of Worship Act. The Supreme Court has given the government the deadline of October 31 for submitting its viewpoint on the 1991 law. Subsequently, the court will begin hearing the case. From past experience, there are fears that the ASI findings will be leaked to the media. This may only influence various processes, political or legal. The ruling of the High Court and the Supreme Court jeopardizes the existence of not just the Gyanvapi Masjid but also the Shahi Idgah in Mathura, as similar cases are moving towards denouement of sorts. The fear of the Sangh Parivar's Demolish-mosques-to-restore-temples campaign becoming a never-ending one appears to be coming true, as winning elections have become the primary objective of the current regime, as recent events, whether in Manipur or Haryana, demonstrate.
Subscribe to the Federal's YouTube page for more news and updates.